as much as a resident of outside Kashmir could not say, why am I made subject to parliamentary legislation when this subject in the state of Jammu and Kashmir? Could an Indian complain, could a person outside Kashmir, a fellow Indian, say that my fellow Indian there in Jammu and Kashmir has a right to property? If you take his property, you have to pay him full compensation. But if I am outside Jammu and Kashmir, take my property and you can show me a blank piece of paper and there's nothing I can do.
G70 now leads to the abrogation of 19(1)(f) in Jammu and Kashmir.
It does.
But which is not a part of the basic structure. 19(1)(f) has been held not to be a part.
It is not as much today. If you are creating a larger equality, the solicitor has developed this point, you've created a larger equality. Where is the question of violating 14? And individuals, my lord, that principle must be extended. Then it says the power of Parliament to make laws shall be limited to those matters in the Union and the concurrent lists which in the consultation with the government of the state are declared by the President to correspond to matters specified in the instrument of accession. So this was on the issue of the legislative lists and that schedule, matching them with our 7th schedule, and the President would decide how the 7th schedule is to be divided. And here it's only consultation consistent with the philosophy that accession and instruments of accession, these are what are in international law called political documents, not political in the political sense. Political
I think, Mr. Salve, it's very clear now. If the President wanted to make any exceptions or modifications,
yes,
in respect of defense, communication, or external affairs, then only consultation was required.
Correct. Now, my lord,
of the first proviso to clause D.
Correct. Now, my lord, applying other provisions of the Constitution, and my lord, I don't have to give your lordships a catalogue of which are the other provisions. I mean, there are so many important provisions of the Constitution. They would be phased in and applied under D.
Right.
And for that, they said concurrence.
They would require concurrence.
They would require concurrence.
They referred to either defense,
correct.
The
legislative lists,
affairs or communications.
Broadly, let us say the legislative lists are put to one side because that is really power to make laws. Yes. But for institutions, your lordship's jurisdiction under 32, for example.
The Constitution also, yes.
Your lordship's jurisdiction under 32. Should it extend or should it not extend to Jammu and Kashmir? These are, and what about public service commissions? What about election commissions? So on and so forth. So, not all those were provisions to be applied, if necessary, with adaptation. Now, what is important? And I come back, therefore, to my point. How does this align with a complete accession? Article 3 is the answer. That this is an arrangement for the phased introduction of the Constitution, keeping or reserving unto the President the power to disapply this article. Now, obviously, for that, there cannot be concurrence. So it makes sense. Recommendation if there is a Constituent Assembly, otherwise, the action of the President. This was the arrangement, this was the compromise. And my lord, this compromise was not just with the state of Jammu and Kashmir. The solicitor has placed before your lordships the sharp differences of view, even in the Congress Working Committee. They rejected this plan. First time when Shri Gopal Ayangar presented it. Sardar Patel's letter is cited in the solicitor's list of dates. He said, sorry, I don't accept these. So this was a very matter with more than one point of view and competing points of view. So this was the compromise formula, which is incorporated here in the Constitution. This was the workable arrangement. This is all right. Ultimately, we will decide and we will keep to ourselves the power to disapply this article. But if this works phase by phase, introduction of the Constitution, why not? And it did work to a large extent. So one of that principle, which my lord the Chief Justice was pleased to put to me, about lesser power and larger power, would it not require greater safeguard? That would not occur. That's what I call the contextual argument. I'm not finished with this, and I have eye on the clock. If there's anything more, I can assist your lordship on this point. Otherwise, let me move to my next point.
I think we can move to your next point, Mr. Salve.
Yes. Second point is, my lord, there has been some arguments about even if 370 applies, because no radical change. And Delhi laws was cited. Now, my lord, some cleaning up because some principles need to be clearly stated. The Birla cotton mills in Delhi laws, the power to extend laws, you cannot make radical changes. But that can have no application here. That principle can have no application here. Because your Lordship has seen those cases. Your Lordships read down the power to extend and apply laws under Article 14. The argument was excessive delegation. You have conferred upon the executive the power to change a law made by Parliament and its application. And that is why your Lordship said we read it down. That the philosophy, the basic policy of the law cannot be changed, radical changes cannot be made. My Lord, 370 is a part of the Constitution itself. There is no question of excessive delegation. This is a power conferred on the President. And that is why my Lord Lakhanpal rejects this approach. But I was giving your Lordships an answer on first principles.
Yes.
The power, my Lord, under 370 is plenary in nature. And this is a power conferred by the Constitution. A plenary power is not subject to the principle of, or is not amenable to a challenge of excessive delegation because the Constitution has made this delegation. Where Parliament makes a law which is subject to Article 13, or where the state legislature makes a law which is subject to Article 13, then an Article 14 challenge can be brought saying this is excessive delegation. And all the Delhi laws, in Delhi laws downwards cases, all dealt with excessive delegation. In statutory provisions on the anvil of Article 14, it is completely irrelevant to 370. Your Lordship has already said this in Puranmal, but I wanted to just put it on first principles.
Yes.
The second point is that the power exercise is legislative in character. I don't think I need to belabor that point very hard. Applying provisions and disapplying provisions, modifying provisions of a law is legislative in character. I don't think I need to cite authority for that matter. To suggest that this is an executive power is like saying ordinance making is executive power. And it is done by orders. Malad, I'll just give your Lordship a citation. 1972, one Supreme Court case is 148, just for reference, where your Lordships have said that, because there also the President can by order say this and by order say that. You're not saying this. So this is now what follows from a plenary power and a power which is legislative in character. It has a direct bearing on the next issue of the extent of judicial review, of the exercise of that power.
He says, subject to such exceptions and modifications as the President may order by order specify.
Yes.
There is a bifurcation.
Yes.
Matters which refer to the instrument of accession require consultation. Other matters, other than those governed by the instrument of accession, require concurrence.
Correct. Now, the point which I was making, perhaps that got lost.
We wanted you to just come back again. Yes.
So again, my Lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, my Lord, instrument of accession requires consultation, not concurrence. The first proviso. Why this dichotomy in the first and second proviso, my Lord? And that also, my Lord, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
yes,
clause B of 371B,
yes,
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the President, the power of Parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of Parliament to make the law. There is no power to make exceptions or modifications in clause B at all.
No, not at all.
Bifurcate. You correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because these matters clearly specified in the IOA: defense,
correct,
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required.
Yes.
Because they were specified in black and white in the IOA.
Correct. But
matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
And my lord,
now when it comes to
yes.
D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
consultation.
Only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And my lord, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363, that these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article, that if you want to completely disapply this political arrangement, if there is a constituent assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370 is absolutely on the same is on the same
philosophy
or is the same platform as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, my lord. The underpinning is the same.
The first proviso to D and B1.
Yes, and because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president. Instead of driving one to Article 368, they reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive president is executive government, where the executive government can disapply a provision of the constitution.